Good morning, friends. My today topic is KAUSHAL versus the state of Uttar Pradesh, government of UP, Home Secretary. This case was decided on 3rd January 2023, and the bench constituted was Honorable Justice Shahid A. Nazir, Justice Bhushan R. Ghoi, Justice Aji Kutiria S. Bopanna, Justice B. Rama Subramaniam, Justice B.B. Nagaratan. Friends, the main questions in this before this constitutional bench were, are the grounds enumerated in Article 19 supply 2 of the Constitution the only reasons for which free speech can be restricted under the Constitution? Second issue was, can fundamental rights under Article 19 and 21 of the Constitution be enforced against non-state actors such as other citizens or private companies? Third issue was, is the state duty-bound to protect the Article 21, that is, right of the citizen, when infringed by non-state actors? Fourth issue was, can a statement made by a minister about state affairs be attributed to the government? Fifth issue was, can a statement by a minister inconsistent with the fundamental rights of a citizen be held to violate citizen rights? These were the issues. Now let us firstly dive into factual background. On 29th July 2016, a woman and her minor daughter were allegedly gang raped on the national highway. The victims petitioned before the Supreme Court seeking transfer of the trial to Delhi from Uttar Pradesh in the hope of a fair investigation. The victims also sought action against Mr. Azam Khan, Minister for Urban Development in the Uttar Pradesh cabinet, who had labeled the incident as opposition conspiracy hatched to defame the state government. On October 5, 2017, a three-judge bench referred the questions arising for consideration in this petition to a constitutional bench of 5 judges. And on 10th November 2017, the three-judge bench clubbed the petition with an appeal from Kerala that raised similar issues. The appeal challenged the inaction of the government of Kerala in addressing derogatory statements about women made by its Minister for Electricity, Mr. M.M. Mani. On 24th October 2019, the Constitutional Bench framed the above-mentioned 5 questions for consideration. Now, let us dive into decision of the Supreme Court and its reasoning. The Honorable Supreme Court found that the grounds enumerated in Article 19, Supply 2, for restricting the right to free speech were exhaustive, and that free speech cannot be restricted for reasons not found in Article 19, Supply 2. The court held that Articles 19 and 21 could be enforced against non-state actors such as other citizens or private companies. It also found that the state has an affirmative duty to protect a person's right under Article 21, even against non-state actors. The court held that a statement made by a minister about state affairs could not be attributed to the government. It also held that mere statement by a minister which undermined the fundamental rights of a person or citizen would not be actionable unless it led to an action, act, or omission of public officer that caused harm or loss to the person or citizen. The judgment of the court was authored by Justice Rama Subramanian, and Justice Nagaratna wrote a separate opinion which descended on certain issues. The constitutional bench of the Supreme Court directed that the petition from Uttar Pradesh and appeal from Kerala be listed before regular benches of the court to be decided in accordance with the principles laid down by the constitutional bench. Now, friends, let us dive into reasons for decision. First observation was exhaustive nature of Article 19, subclause 2. The explanation is the Honorable Supreme Court found that the 8 grounds to impose reasonable restrictions on free speech were comprehensive and exhaustive. They anticipated all possible attacks on individuals, classes of people, society, state, court, and the country, the subjects whom the article sought to protect. Free speech could not be restricted for any additional reasons, including by invoking other fundamental rights. Where two fundamental rights stack rival claims, they were to be balanced using established tools of judicial interpretation. Now, second was enforceability of fundamental rights against non-state actors. The Honorable Supreme Court found that some fundamental rights were enforceable against non-state actors. The court acknowledged that although it had been wary of extending the enforcement of fundamental rights to private individuals, its approach had evolved over time. Rights once exclusively enforced against the state were gradually enforced against private individuals with regard to public duties or functions they perform. Hence, the court held that Article 19 and 21 could be enforced against parties other than the state and its instrumentalities. It observed that initially, only the state-wide thought capable of lawfully depriving a person's life and personal liberty. However, over time, violation of Article 21 by non-state actors had become possible. First, this was because Article 21 has been interpreted to include a host of associated rights to protect persons' dignity, such as right to livelihood and environment. And secondly, traditional government functions had been outsourced to private actors and public-private partnership. Justice Nagaratna disagreed. In her partially dissenting opinion, she held that fundamental rights under Article 19 and 21 could not be enforced against private actors unless they had been recognized in statute or common law. Enforcing fundamental rights against non-state actors would ignore the difference between fundamental rights and a common law. However, a writ of habeas corpus could be sought against a private person for an Article 21 violation, since illegal detention, whether affected by the state or a private party, had an identical effect on the life and liberty of the detainee. Now, government not responsible for individual minister's statement. The petitioners argued that ministers making wayward statements should be subject to disciplinary action. However, Honorable Supreme Court stated that a code of conduct for ministers could not be enforced in the court of law, and that the Prime Minister or Chief Minister did not have disciplinary control over the Council of Ministers. The Supreme Court concluded that a statement made by a minister about state affairs or to protect the government could not be ascribed to the government by invoking the principle of collective responsibility. It observed that the principle of collective responsibility envisioned in Article 75, subclause 3 and Article 164, subclause 2 of the Constitution required the Council of Ministers to be responsible to the legislature, nor the Chief Minister or the Prime Minister. Even though each individual minister is responsible for the decisions taken collectively by the Council of Ministers, the statement of individual ministers made outside the legislature could not be attributed to the Council of Ministers. On the contrary, Justice Nagaratna, in her partially dissenting opinion, held that a statement by a minister made in an official capacity could be attributed to the government if it were representative of the views of the government itself. Now, requirements for a constitutional tort. Honorable Supreme Court found that the government could not be held responsible for a mere statement by a minister which undermined a citizen or person's constitutional right. It could only be held responsible if, as a consequence of that statement, public officers did or failed to do something which caused harm or loss to the citizen or person. Justice Nagaratna identified the need for a proper framework to determine the acts and omissions of the government agents which would constitute a constitutional tort. She noted that the government would not be held responsible if the statements of its agents caused harm or loss to the citizen or person unless the views expressed in the statements aligned with its own. That's all. God bless you all. See you again.